Meeting number 7, our last meeting of the interim. Glad to have everybody here, and I appreciate everybody making arrangements. I know a lot of committees have met this week. Here's we're getting close to Christmas, and December's not a normal month that we meet, but there are occasions and times when committees need to have extra time, and I'm glad a number of committees this week have had that time, including us. With that, did Vice Chair, did she have a guest you wanted to recognize who might
Yes.
just be outside the door?
Thank you, Mr. Chairman. I have a guest right outside the door that I asked to be called in, Sharon Spicer Feltner.
Did he make it in?
I don't know that they know. I mean, somebody who calls them. Can someone ask for Sharon Spicer Feltner to come in? Feltner? I'm sorry. Unless they appear immediately. I'm sorry, Mr. Chairman.
It's okay. Anybody else have any guests while we're waiting on Representative Decker's guest to come in? We can sing Christmas carols.
That's all right. I don't want to take up more time.
That'll clear the room.
Yeah, that would clear
Thank
the room.
you.
Yes, ma'am.
I don't
All
see
right.
them. Oh, here they are. So, Mr. Chairman, most people who work in the Capitol know Michael Frazier. He's a friend to many on both sides of the aisle. Today is the first time his mother, Sharon Spicer Feltner, has come to the Capitol to see where her son works. So if you would all please welcome her and make her. Thank you. Thank you.
We're glad to have you. Thanks for sharing your son with us. He comes to see us on a pretty regular basis, each one of us at different times, so I appreciate it. Good to see you, Michael. All right. Is there a motion to approve? We need to do the roll call. I'm getting ahead of myself. Mr. Secretary?
Senator Berg,
Present.
Senator Carroll,
Here.
Senator Deneen,
Here.
Senator Neal, Senator Schickel,
Here.
Senator Stivers, Senator Storm,
Here.
Senator Turner,
Here.
Senator Wheeler,
Here.
Representative Banta, Representative Blanton, Representative Bratcher,
Here.
Representative Bray,
Present.
Representative Burke,
Here.
Representative Decker,
Present.
Representative Dietz,
Here.
Representative Flannery,
Here.
Representative Herron,
Here.
Representative Kulkarni,
Present.
Representative Lewis, Representative Maddox,
Here.
Representative Mosier,
I'm here.
Representative Nemus, Representative Petrie, Representative Rawlings,
Here.
Representative Sharp,
Present.
Representative Stevenson, Representative Wilson, Co-Chair Westerfield,
Here.
Co-Chair Elliott.
Do we have a quorum? Very good. All right. Is there a motion to approve the minutes of our November 3rd meeting?
Motion.
Motion by the chair. Is there a second? Second. A couple of seconds. Thank you, Representative Flannery. Any adjustments, questions, edits, or anything? Questions about? Seeing none, all those in favor of approving the minutes, please vote by saying aye. Aye. Those opposed? Minutes are approved. First item on the agenda is crisis aversion and rights retention orders, and I'm going to head down to the table, Chairman.
Absolutely. You are recognized, Co-Chairman Westerfield. If you'll introduce yourself for the record, and your guests can introduce themselves as well.
Thank you, Chairman and committee members. My name is Whitney Westerfield. I'm the 3rd Senate District Senator for the counties Christian, Caldwell, and Muhlenberg counties, and proud to serve as co-chair of this august body with you. I'll let my guests introduce themselves here before we jump into remarks very quickly.
Hi, I'm Whitney Austin.
We're here, microphones, we're having trouble hearing everybody closer.
Hi, I'm Whitney Austin, the Executive Director of Whitney Strong.
And I'm Steve Shannon. I'm the Executive Director of CARP, Association of 12 of the 14 Community Mental Health Centers.
Good morning. I'm Rick Sanders, currently Chief of Police in Jeffersontown, Kentucky.
Chairman, thank you. Members, thank you. A lot of interest in this bill, and I understand why. In the first winter after I got this job, I was at our caucus retreat actually in one of the committee rooms here, and there was a school shooting at that time when we were having our caucus retreat. I remember us stopping and praying and then moving on with things. We didn't spend a lot of time talking about it. There wasn't any legislative action on that. Not that I recall, certainly, in that following session. In the intervening 11 years, there have been a number of shootings, awful acts around the country. And they all get our attention for a few days. They don't seem to last beyond a few days or maybe a couple of weeks, unless you've been touched by that directly, as Whitney has been, and she'll talk about that. But that changed for me last May of 22, the day of the Uvalde shooting. It wasn't substantially different from the other shootings that we've seen at schools in particular, but it bothered me in ways other awful acts that we've seen, mass shooting events that we've seen, didn't. And it bothered me because the little boys and girls that we were seeing stories about, or that we saw were killed, or we heard calls from, or pleas from, heard stories about and read stories about, were the age of my kids. And it really bothered me. It bothered me then. It continues to bother me today. And I felt compelled to try to come up with a solution. That day I opened up a bill request for CAR. Didn't file it this year, but I've continued to work on some version of this bill, crisis aversion and rights retention. And there are a number of other states around the country that have done something similar to this, but I tried to make it different. I tried as a Second Amendment supporter, as a gun owner, former NRA member. I wanted to make sure that it was constitutionally sound. And so I set out to try to do that and come up with a version of this bill that didn't present some of the same problems that prior attempts at this, not only in Kentucky but in other states, has done. I believe there is a continuum of Kentuckians, so to speak. Everyone agrees law-abiding citizens ought to have firearms. The Second Amendment guarantees it. Everyone generally agrees, though I think there might be members of this body or the legislature broadly that might quibble over certain specific examples, but I think generally there's broad agreement that felons don't have that right anymore. At least there's no rushing of the door of our colleagues, all of us, filing bills to allow felons to have those guns again. So I think there's broad consensus that there's that category on the other end of this continuum. And there are already instances where under law in Kentucky and around every other state in the country, we already pull guns and remove guns on a temporary basis from people that are in domestic violence situations. Though, admittedly, there's a case that the Supreme Court, U.S. Supreme Court, right now is considering. The Rahimi case. Oral arguments were about a month ago. That might change that, might not change that. But there are already some instances where, on a temporary basis, firearms can be removed from somebody if they pose a sufficient threat. What I'm trying to do is to identify best I can, and you all, I don't claim to have a perfect solution here. I'm going to give you some details of 2 different drafts or versions of this, and you don't have them in front of you because it's subject to change a lot. But I hope to get your feedback and input and tell me where I've screwed this up or where I can make it better. And for some of you, if it's okay, it's okay if it's never going to get somewhere you're comfortable with. That's fine too. But I feel compelled to try. And I feel like it's my obligation, and though I can't speak for you, I believe it is your obligation to not be afraid to have difficult conversations about the toughest issues the people of Kentucky face. And this is a tough one. And we were reminded of that just this April. Or March, whenever I'm sorry, I'm drawing the blank on the date of the bank shooting.
April 10th.
Thank you. So, 2 versions of this. Keeping in mind that the vast majority of the shooters involved, there's some data that suggests about 87.5% of the shooters not all of whom survive, obviously, so this is based on those who did survive, but 87.5% of the shooters in these mass incidents. And we're also going to talk about suicide quite a bit this morning, but the vast majority of those people are struggling with either misdiagnosed, undiagnosed, or untreated behavioral health or mental health issues, trauma of some kind, PTSD even. There are instances where, and we've seen even in the most recent shootings, cases where people knew the shooter was struggling with this. In fact, if you have a criticism of these bills around the country, one of the criticisms is that they're underutilized in the states that still have them. And if Kentucky ever were to enact something like this, we can't make that same mistake. So I set out to have a new version. One of the biggest objections is the ex parte hearing, right? You want to have due process of law and protections there. The Second Amendment guarantees a right. If you're not a convicted felon, we generally agree you should be able to have a gun. And the ex parte hearing creates some problems for folks, and I understand why. And so we set out to try to find a way to do this without having an ex parte hearing. So the version that I've shopped around to a handful of people, some of whom like where I'm going, and some people hate where I'm going, and some people have practical concerns about it. But I'm going to give you that description and how that turned into the second version, and I'll talk about that as well. There is no ex parte hearing. Instead of having an ex parte hearing, for those of you not familiar, in these bills around the country, the petitioner can seek an order from the court, and the court reviews that. The court reviews that on their own without the respondent or the gun owner in the room. And if they find it's compelling enough, it meets the standards, they issue an order, temporary. Law enforcement exercises that order or enforces that order and collects the guns. And then there's a hearing a week or two later. That initial review without a hearing creates a lot of concern for people. And so I wanted to come up with a way that didn't have that step. What we came up with is having that petition, and I'll point an important distinction between ours and a lot of other states. You can't just anybody go and get this petition and ask a court. You've got to convince a law enforcement official, an officer, to petition the court. And in this particular case, that individual can petition law enforcement. And the law enforcement then, instead of going to court, goes directly to the respondent and gives them an option. And there are some protections and controls about when you can do this. You can't do it in the middle of the night, that sort of thing. But it gives the respondent the option. You can have a hearing within X number of hours near immediate. Keep your guns until then. Not keep your guns, that's up in the air. Or you can give us your guns now, and we'll have a hearing in a week. And again, the time periods in there are changeable and adjustable. The burden is on the respondent, in that particular case, to make sure that and the standard in the current draft I have is probable cause, but there are other versions than we've tried beyond reasonable doubt, which is something people have asked for in the past. It is a standard somewhat less than the standard for involuntary commitment under 202A, because if you've met that standard, then you need to be involuntarily committed under 202A, which also deprives you of your rights to your firearms for at least 72 hours. But the respondent has the burden of defending that in that particular case. But at least they've been given a chance right there at the moment to have a hearing within, and the draft I've circulated, and there's some judges behind me that have read it. I had 2 hours. You can have a hearing in 2 hours, or give us your guns and we'll hold them for the week, and you have a hearing, a full-blown hearing in a week. There are some practical problems with 2 hours. If you're a district judge or riding a 4-county circuit, 2 hours might not be tenable, though I think remote attendance might be an option to solve a lot of those problems. But judges that have seen this have reached out and said that presents an issue. And so I came up with a second version. If that's not realistic, and again, I'll tell you the problem with it is that if you tell someone that you fear has got a mental health issue or a trauma of something that you're worried they're about to break, and then you don't act with some near immediacy, you might actually provoke the act. That's the concern. And you're balancing that risk and that concern with the Second Amendment right that they have. And no one disputes that they have. So that's first option. Option two, we do bring the ex parte hearing back in for this option. Then this particular path, if this is the way that there is more support for. But something that is in this bill that has not been in any prior bill, and I'm not familiar with I think there are 19 or 20 other states that have something like this. I don't know if another state has it. But this follows the 202A schedule and protocol. So all the district judges are familiar with that. It's a near immediate review of the petition. It still has the law enforcement step, so it's not just anybody on a whim asking for a judge to get your guns. There has to be some articulated, specific reasons for the basis for the order. But with this ex parte hearing and following the 6-day or 5 or 6 day protocol under 202A, this would be 202D. Someone suggested 202G for gun. I don't know if the statute revisers would let us do that since D is the next one, but put under that statute enforcing the fact that the mental health response is the key here. That's the whole point. And I'll remind you, and I'm going to read it. This is from Heller, Justice Scalia, beloved by Republicans, and people that are paying attention to this issue already know this line from the case. Like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment, so forth, so on. The court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill. And that's a summation of language that appears in the opinion, but we should be able to identify that and come up with some solution to respect the Second Amendment rights while still protecting that individual from themselves or from the harm of others from that person. In this particular case, the unique thing is the presumption that the guns should be returned. It's rebuttable, but the presumption, the default position is that the guns be returned to that respondent, or that the guns not be taken from the respondent in the first place. And then on every subsequent review, the presumption is, and that puts the burden on the petitioner. Whether it's law enforcement or someone else on their behalf and their witnesses, they have to show each and every time it's reviewed that that's the action. Those are the two proposals I've got. I'm going to let my other witnesses speak, and I've gone longer than I aimed to, but I wanted to highlight that. And the reason you don't have a bill draft, apart from the fact that there are these two versions that are very fluid, we've made a slew of changes. I expect I'm going to get a lot of questions and feedback today about things that need to be changed and altered further. I do plan to file the bill, and when I do, I want it to have your feedback and your criticisms factored in. Whitney.
Thank you. Chair Elliott and Westerfield and members of the Judiciary, thank you. I am truly grateful to have this opportunity to discuss a solution for preventing crisis moments, crisis, aversion, and rights retention. While my voice is just one, please know it represents thousands of Kentuckians who subscribe to the Whitney Strong approach to reducing gun death and injury in this state. The voices of many, some of whom are here today and others who could not join us, like Mac Brown, Dr. Sheila Schuster, and Missy Jenkins Smith. Their statements and those of others lending support to this effort are in your packets. Collectively, we all believe in making communities safer through respectful dialogue, following the data, love for one another, and seeking common ground. Collectively, we know it is important to understand what CAR is, just as it is to understand what it is not before deciding what is right for Kentucky. To begin, I want to start with our collective desire to protect innocent life. As a gun owner leading my organization that represents a very diverse supporter base, I know every day from conversations that gun owners and non-gun owners alike, Republicans and Democrats, we all align on this foundational value. And on September 6, 2018, I saw this shared value collapse, and to the detriment of myself and thousands of other people in Cincinnati, Ohio. On that day, I faced something that I can only describe as hell on earth. As I walked into the corporate headquarters of Fifth Third Bank, I found myself stranded in a revolving door, taking gunfire from a severely mentally ill man who was in lawful possession of a firearm. For one agonizing minute, I lay there helpless as 12 bullets entered my body, coughing up blood and trying as hard as possible to remain lifeless for fear that he would fire the next round into my body. And while that was happening, all I could think about were my precious children and my husband, and begging God that I would live to see them again. Now I just want you to take 1 minute, a second, think about those you love most, and think about that trauma being inflicted upon them. Think about your innocent spouse, your parent, your friend, or God forbid, your child. I am telling you, there is nothing that you wouldn't do to prevent them from experiencing this. The collective, or our shared humanity, I believe, calls on us to prevent this violence. It calls on us to reconcile the role we have all played in allowing these incidents of mass violence to play out unrestricted. Sorry, 1 second. It calls on us to carefully and thoughtfully consider why. Why, despite the all too frequent misuse of firearms we see going on around us, we recoil at the prospect of change, why we recoil at the prospect of taking clear steps to help gun owners before they misuse their guns, or at the opportunity to do what is right for Kentuckians, gun owners, and non-gun owners alike. Since 2018, I have traveled a long road of trauma, and along the way, I have met far too many others who have been forced to travel this path with me, some of whom are very bravely here today, and I want to recognize them. We must lift up my friends Marianne Elliott, who's right behind me, Jeff Barrick, who's to my right, and then Karen and Andrew Tutt, who are right behind me. Here's the date. It was April 10th, 2023, that their loved ones were brutally murdered in a mass shooting at Old National Bank. The shooter, while mentally ill, was in lawful possession of a firearm. We must also lift up my very brave friend Kirsten Russell, who's here today. On April 23rd, 2018, Ruth, her mother, was viciously murdered by her mentally ill son in her own home. Her family had sought a mental inquest warrant, but it was denied. Just like the rest of us, he was in lawful possession of a firearm. We must lift up the many other brave Kentuckians who are here with us today who have lost loved ones to suicide by firearm, domestic violence involving firearms, and more. In our shared humanity, it is time that we lift up those who paid the price for our collective inability to solve for this problem. It is time for those, perhaps some in this room, with the tendency to say no or never, even before fully understanding all of the options, to think about how we, the collective, can help save those innocent lives, help gun owners and those around them, and help before these crisis moments turn into tragedy. It is time. Let us solve this problem together, and let's start first with the data. For the most recent year on record from the CDC, which was 2021, there were 947 gun deaths in this state. This is an average of one person killed every 9 hours, and that included 93 of our children and our teens. And a majority of Kentucky gun deaths, which people don't realize, 56% were suicide. That represents 534 lives. Gun violence has only increased in our great state in the last decade. From 2012 to 2021, the gun death rate increased 43%, And you can see the division here between firearm suicide and firearm homicides. Now let's talk about homicides. In 2021, 89% of homicides were completed with a gun. Homicide with a firearm impacts males at a rate that is 5 times greater than females, Black people at a rate that is 14 times greater than white people, and urban areas at a rate that is 2 times higher than rural areas. Also notable, there have been 8 incidents of mass violence in our state just this year. That means 4 more people injured in a public place, 1 in Lexington, 1 in Paducah, and 6 in Louisville. And then I want you to really look at that heat map to the left, because suicide tells an entirely different story in our state. In 2021, 65% of all suicides were completed with a firearm. Suicides by firearm impacts males at a rate that is 8 times greater than females, rural areas at a rate that is 1.4 times higher than urban areas, and the populations with disproportionate impact include white males, veterans, farmers, and minors. And while the narratives surrounding gun deaths in our state are often tied to urban areas, the 3 counties with the highest gun death rates from 2011 to 2020 were all in eastern Kentucky: Wolfe, Knott, and Lee, largely driven by suicide. So what is the problem? As a supporter of the Second Amendment and the executive director of an organization that includes many gun owners, let me start with what it isn't. We know the misuse of firearms is not tied to law-abiding, mentally well gun owners. CAR was not created for them. CAR was created to surgically identify the small subset of gun owners, including those in lawful possession of a firearm, who are on the brink of misusing their guns to harm themselves or others. When faced with this current scenario, authorities have no legal path. Let me say that again. There is nothing today, no legal path to press pause and temporarily transfer those firearms away from the person and finally put them on a path to rehabilitation, all the while preserving their right to go on to continue to own that firearm. CAR is the solution to this problem. It protects innocent life by preventing crisis moments with guns. It is a helping tool. It is designed to get gun owners back to a place in which gun ownership is safe, and it protects the individual Second Amendment rights by hitting the pause button long enough to get them the help that they need. Let us focus our energy on preventing the next mass shooting in our state, or on gun owners who need our help, gun owners who are struggling with suicidal thoughts, or on gun owners buckling under the weight of this world and considering choices that they would otherwise never make. Perhaps some of you or some of us in the room know such a gun owner. Why wouldn't you want to help them? Thank you.
Good morning. As I said, I'm Rick Sanders. I'm currently the Chief of Police in Jeffersontown, Kentucky. Many of you in this room I know, but some I don't. So I think it's important for you to know who I am and why I'm here. I have been in law enforcement for 4 decades. I've been in federal law enforcement, state, and local. I began my career in the 70s as a young police officer, 20 years old, on Dixie Highway. I have seen trauma. It's not anecdotal. It's not something I've read out of a book. It's what I know. We've come a long way in law enforcement. We're much more professional today than we were back in the 70s. We have many more tools to use in helping us do our job. But we're faced with things today that I have never seen before. And one of the biggest problems we face in law enforcement is people suffering from mental illness. I'm going to I've got pages of things I could talk about, but I'm just going to use a couple of examples of why I'm so passionate about what I talk about this morning. I'm a Second Amendment advocate. I've got a safe full of guns in my house. But I also recognize that there are people suffering from mental illness that shouldn't have access to a weapon. And I'll use another analogy. When my uncle was suffering from dementia, I took his keys away from him. It wasn't the car's problem, it was his problem. He was suffering from mental illness. And I think it's much the same way when we talk about what we're talking about today. This is not a gun problem. This is a mental health issue, and we have to address it. On January 23rd, 2018, at 8:57 a.m., my executive assistant walked into my office. At the time, I was commissioner of the Kentucky State Police. She said, "Commissioner, we have an active shooter situation over near Benton, Kentucky, at the Marshall County High School, and there are casualties." The governor and I boarded an airplane and flew to Marshall County and went to the school. And when I walked in, I saw 15-year-old Bailey Holt laying on the floor dead. I saw backpacks, phones, shoes of students that had lived through this ordeal and had been facing this challenge. The shooter was a 15-year-old student at that school who suffered from mental illness. And I think when I saw that, I thought, you know, there are doers and there are talkers, and I want to be a doer. We have to do something to stop some of this. There were 2 people killed that day. There were 14 people totally that have been shot, 18 injured in all. He was taken into custody and by a sheriff in Marshall County. And although the SRO did not stop the shooting, I believe he stopped the continuation of the shooting by being in that school. This young man, who I won't mention his name, after shooting all these people, threw the gun down and tried to blend in with other students, but he was apprehended by the sheriff. That young man had taken a gun from his stepfather and had committed this heinous act. He's now serving 2 life sentences, but that doesn't bring the life back to Bailey Holt and Preston Cope. Preston was a young man that was taken to Vanderbilt Hospital and subsequently perished from his injuries. The governor and I actually stood in the home of the Copes and prayed with them and cried with them and grieved with them about what had just happened. That's why I'm here today, not to take guns away from law-abiding citizens. I will advocate for the Second Amendment from now on. But there are some people that are in a condition of mental illness that should not possess a gun. And I think we need to work this bill through. I started talking about this a year and a half ago when Senators Paul Hornback and Morgan McGarvey, a Democrat and a Republican, came to my office with Whitney and said, "Chief, can you help us? We've been talking about this for that long." And my good friend Senator Westerfield, thank you for having the courage to bring this forward today. This is not an end product, but this is something what we're bringing to the table to talk about to try to save lives. And that's what the purpose of this bill is. I can also talk about when I was a young police officer out on Dixie Highway. I had a suicidal subject who had a gun. I was young and full of it back then, and I sat across from him and watched him as he talked about committing suicide. And then I saw him shoot himself in the mouth. Needless to say, I did not become a hostage negotiator after that. But, you know, the sadness that I saw from someone suffering from mental illness that took his own life in front of me has stayed with me for the years. Again, my family is 4 generations law enforcement. We're all gun owners. We're all avid shooters. And I'll go to the range with any of you that are law-abiding citizens. But there are some people that have shown that they're suffering, and we need to take the firearm away from them before they can hurt themselves or others. You know, in 2015, we faced an opioid crisis in J-Town, and we thought outside the box. We started an angel program where we invited people to come in and the police would help them get assistance. People thought I was crazy for doing that. We have now helped over 3,000 people that have substance abuse disorders, which is another form of mental illness. So we can't sit back and say, nope, never going to happen. We got to work on this. We've got to get together, Democrats, Republicans, independents, and talk about how we can fix this. I know there's another bill coming up right after us, and I could testify on that one as well. Anybody that knows me knows that I'm a law and order guy. I'm unapologetic for locking up bad guys. But we've also got to think outside the box and try to keep people from killing people like my comrade or my partner, Officer Nick Wilt, who was shot in the head in a bank in Louisville a few months ago by someone suffering from mental illness. We have got to do this, and I commend Whitney, both Whitneys, for having the courage to bring it before you today. Thank you.
I'm Steve Shannon. I'm with the Association of Community Mental Health Centers. This is a serious issue, and I think the mental illness piece for me is an acute episode of mental illness for many people. And at that point, they need treatment. Okay? I'm going to tell you the truth. It's not a secret. My members won't like me talking candidly. We have been profoundly underfunded for a long time. Right, Senator Westerfield? Yes, sir. Profoundly. I would love to tell you we can address all these problems on the spot. That would be disingenuous and dishonest of me to do so. We have tools. Kentucky has current statute for involuntary treatment. You heard about 202A. That's an involuntary hospitalization for 72 hours. But you got to know about the person. The process has to start. There has to be, and it's due process, but it has to be initiated, and the person has to meet the need for hospitalization. Not everybody meets that need. The situation here earlier, they probably didn't meet that need for hospitalization, so they didn't go to the hospital. And if they do go, 72 hours. You can extend it, but it's 72 hours initially. It's involuntary treatment. There's court order outpatient treatment. I think Judge Burke is here somewhere. She's a champion of court order outpatient treatment. But again, it's court ordered, it's involuntary. The person has to have a history of not participating in treatment. They have to be known to the system. They have to be aware. They were supposed to go, take their medicine, go to therapy, and they didn't. Part of what I want to talk about are those folks who we don't know about. And a lot of those people are untreated mental illness. And when I think mental illness, what comes to my mind, the visual, is a person in my neighborhood who was homeless. And I live downtown Lexington. My daughters, as young children, knew if it's summertime and they're wearing a parka, that person's not taking their medicine. Wintertime and they're wearing shorts, that person's not taking their medicine. My daughters could do that at a young age as an indication. We're talking about other folks who are in acute mental health crisis, whatever it might be. Might mean they got a call from their spouse saying, I want a divorce. And they take action. This is the true story. They take action. They leave work, I'm getting out of here. Co-workers thought, I'm leaving work today. The individual is saying, I'm getting out of here. Went to Walmart to purchase a handgun. Said to the sales clerk, I'm going to go home and kill myself. Sales clerk called the police. It didn't happen. Access was denied at that point. Not forever. At that point, access was denied. Another story, an individual, after their junior year of college, had a tough summer. Junior year wasn't great. They went home for a while and stayed in their room. Eventually hospitalized, but stayed in their room. Person graduated college, was the best man at a wedding. 2 people call him uncle. He cared for his aging mother. It's my good friend Howie. He was my college roommate. He didn't have access. He didn't have access. Therefore, a bad thing was averted. CAR is a prevention tool. It's not a treatment tool. Prevention is an evidence-based practice. Prevention works. This is what CAR is, prevention, maybe early intervention. Let's not have a bad thing take place. Let's have someone, a family member, a bystander. This person needs help, and take that action and temporarily remove firearms. For me, it's temporarily remove firearms. Suspend it. I'm not a gun owner. I've read the Second Amendment. I have no problem with gun ownership. My good friend Howie is a gun owner now. But sometimes folks need to be protected from themselves, and that protects themselves and others. And CAR's about preventing bad things from taking place. Are we going to get to zero? No, we're not going to get to zero. 85 to 90% of suicide attempts with a firearm are fatal. 85 to 90%. 55% of men use a handgun, a firearm, when they commit suicide. 30% of women. Number one, we need to do something about this. We need to say, let's figure out how we can move forward. I don't have the compelling stories that my friends have. I admire Senator Westerfield for bringing this on. Long history. I knew his dad before I knew him. A long history of what can we do to make lives better for people. We need to take action to say, let's stop this now. We passed a law 202C recently to make sure people who couldn't participate in their defense remained in a forensic psychiatric unit. Didn't have that before. People were released, right, Representative Nemes? We changed that. We changed that. Let's move forward and say, for now, Steve, we're going to ask voluntarily, right? But we're going to have a mechanism to take your weapons away for your safety and the safety of others. So things don't happen. A mental health center in this state has responded to 2 school shootings. I don't think there's another one in the country that's responded to 2 school shootings. I've been at CARP I'm in my 27th year. My first CARP meeting was the month after the Heath High School shooting. We spent the whole day talking about the response then. I learned the value of community at that point. That's what taught me about it. But showed up at school, bad thing happened, no one took action. This creates a mechanism for someone to say, let's hit the pause button and move forward. And the pause button will be best. CAR is prevention. Prevention works. Let's not have bad things happening when we know what they are, potentially, and remove those things. Thank you.
We'll take your questions, Chairman,
Thank
to the
you.
extent time permits.
Thank you, Senator Co-Chair Westerfield, and thank you, Ms. Austin, for your story. I know we've met, and you have a miraculous story, and I admire your courage. Senator Westerfield, I have a question, and you referenced the 202A law as it currently stands, MDO or MDW. Why isn't that sufficient to take an individual's access to firearms when they're experiencing this mental health crisis? What is the flaw as the law currently stands?
It's a great question. I don't think it's a flaw as much as an inadequacy, or in some instances, more than you need. You heard the story about someone seeking a 202A commitment and it was denied. I think there's a universe of people who present with a severe enough issue that we should hit this pause button and just let's make sure everything's okay, maybe get some help that you need, but you don't need to be involuntarily committed. Not only that, but it's only if you wanted to commit them, and I don't know that everybody on this committee would, it's only for 72 hours. It can be extended. So in some instances, it's more than you need. In some instances, it's not as long as you might need for someone who is more severe. Mm-hmm. I think depending on the fact pattern you might have, I think there's an intermediate step that we should explore. Mm-hmm. That's what this presents.
And I'm not going to hog the time. I know we have a lot of members who have comments and questions. I'm going to recognize Representative Maddox.
Thank you, Mr. Chairman. Senator Westerfield, my long-standing opposition to this proposal is known to you. It's known to my colleagues, and in all likelihood, it's known to most of the folks in this room, so I'm going to keep my remarks brief. The value that I know that we all share, everyone who's gathered here today, is a sincere desire to keep Kentuckians out of harm's way. an earnest desire to prevent the unthinkable. However, we strongly differ on the premise, I feel like. Gun control is not and has never been the answer. Whether you call it a red flag, whether you call it an ERPO, whether you call it CAR, or any other euphemism, you're still talking about a proposal that at a bare minimum has the potential to violate at least 3 constitutional rights, in addition to due process and the presumption of innocence, which is a principle that is deeply enshrined in our American legal system. Leading up to this hearing, I have heard quite a bit about finding common ground. I respect that rationale, I understand it, but to me, our common ground is the Constitution. We've all sworn an oath to uphold it, and regardless of our differences of opinion, that's what we have to do. Now, there is little merit in debating the technical issues that may arise from this proposal, but one aspect in particular of any red flag proposal that I have always taken issue with is in terms of seizure. If you have a situation where you have multiple folks that are dwelling in the same household and a red flag is called in, when law enforcement comes to seize the firearms, do they automatically know where to find them? Are they told where to find them? Do they dig through the entirety of the house? Do they saw into the safe? Do they dig through the barns? Do they dig through the cars? Do they tear apart the Fourth Amendment in the process? I think the question then leads to where we would be in potentially a scenario to have a foot in the door for a registry. And it's also important to note that there are other folks in that household that are not implicated at all in any of this, that have the ability to have their Second Amendment rights infringed upon. So knowing that we already have a system in place that can get folks who are experiencing an acute mental health crisis access to treatment immediately, removing them from that dangerous situation instead of infringing upon our Second Amendment rights, I think that's worthy of noting. I also think, bearing in mind this value that I spoke of, the value of we all want to keep Kentuckians out of harm's way, lawmakers must seriously consider the fact that 94% of mass casualty tragedies occur in so-called gun-free zones. These are places that law-abiding citizens have been stripped of their God-given, constitutionally protected right to defend themselves. And that is precisely why these locations are chosen by those who seek to harm and destroy others. So often, we are told that we must do something. Yes, we must do something. We must fervently resist any effort to pass gun control legislation, and we must be serious about analyzing the data and putting a stop to these ineffective policies that put innocent citizens in harm's way. And we have to encourage privately held entities to do the same. That's the extent of my remarks. I appreciate your remarks and, Mr. Chairman, the opportunity to speak.
Thank you, Representative Nemus.
Thank you, Mr. Chairman. We've talked a number of times, Whitney and everyone else at the table. I want to thank you guys for coming here. I know it's not easy to do. I've talked about this bill a lot with a lot of my constituents on all sides of this issue. I don't know that there are just two sides of the issue. I'm going to ask the other side the hardest question I can come up with as well, or one that gives me pause, but I'm going to ask the same of you on the other side, which is the biggest concern I have with this bill. So I'm going to try to be a lawyer and kick the tires on both sides if I could. I think the biggest problem I have with this bill, and thank you for having the hearing, I think that's important in the due process, but fundamentally, this bill takes away a constitutional right from a citizen based on the prediction that they might commit a crime in the future. And so we've heard today that could be indefinite. It's not just the 72 hours, it could be forever if the judge continues to have that and there continues to be hearings. And so while I understand that the purpose of that or the intent behind that, it seems to me that's a problem. So what do you say to those who say, it's a little Minority Report. I know a lot of us have watched that movie. This person has done nothing wrong. They have not committed a crime. They don't have a history of a crime. They've done nothing wrong. And we are taking their constitutional rights away, perhaps indefinitely. What do you say to that?
It's a good question. the system we have right now limits your constitutional rights or your liberties already based on probable cause. When you're arrested for a crime, you're not guilty of that crime yet. You're presumed innocent. And by the way, this doesn't change anything about the presumption of innocence. This is not a criminal proceeding. This bill doesn't propose any criminal penalty. There's no change to the presumption of innocent. There is no criminal act at all. It can't be used against you in some sort of subsequent case. This is no change or alteration to that at all, or even an attempt to do that. But there are limitations even on other bedrock constitutional rights. Would you agree with that, Representative Nemes? That there are already restrictions on, say, Fourth Amendment. I have a Fourth Amendment right to privacy to my person, my car, and my house, but not to your house, and maybe not even to my yard, depending on the facts of a certain case. There's limits to that. I think there ought to be some reasonable, very, very carefully drafted limits to this. And only because of the people that we've talked about today. Not you and not me. I hope, I pray, not ever. Either of us or people like us and the rest of us that are law-abiding and mentally well, as Whitney said. But we've seen instance after instance after instance after instance after instance of someone who is not mentally well, who was, until the moment they snapped and did publicly what they were thinking about and conceiving of doing, lawfully possessed the firearm. I think and again, I can't speak for any of you, but if you knew that the shooter at the bank in Louisville in April was going to go and shoot all those people, if you knew in advance, I don't think anybody in here would arm him. Do we have to make some best guess based on a list of factors, based on concerns raised by people who know that individual? That's the best that we've got. If you got a different solution, man, I'm all ears. The law has to allow us to protect people in a way that honors the Constitution, but protects people at the same time. It's not an unlimited right. It's just not. And neither are the other constitutional rights. There are limits and lines drawn for all of them. We got to figure out where the line needs to be drawn here. And I don't have the perfect solution to that. But we need to talk about where that line ought to be. That's the best answer I got, Representative.
Thank you, Mr. Chairman.
Thank you. Senator Berg.
Thank you, Mr. Chairman. Thank you guys for bringing this forward today. I'm going to try to make my remarks brief because I don't honestly have a question. Many of you all know it was actually a year ago this morning that I woke up to the phone call that my child had ended his own life. And as a result, on Thursday evenings, I go to a group, survivors of suicide. And it's the only thing, honestly, that has kept me sane over this last year. But every Thursday night, I sit there and cry with family members, every one of them, with the exception of me, and I thank God every day, I thank God that my child did not put a gun to his head, and God forbid, did not go out and kill somebody else with his suicide, because that's what most of these school shootings are. They're public suicides. But I sit and I listen to these parents. The youngest one in my group is 14 years old. Describe what it is like to watch your child blow their head off. And it is unfathomable. And if we could do one thing in this state to prevent one parent from having to go through that, it is worth it. Because this is hell. This is hell. I cannot explain to you to sit there and watch a father say, I cannot see anything else. I cannot see anything else. And people try to say eventually it'll go away. Eventually it'll get a little better. It'll get a little softer. Guys, we are talking about a mental health crisis. A crisis of a proportion that we have never seen. And without acting, we are letting our children kill themselves. You know, one of the mothers last night, her son was a schizophrenic, a known schizophrenic, a diagnosed schizophrenic. Somehow he was able to buy 3 guns without her ever being aware. And she's like, how could that happen? I mean, not only was he a schizophrenic, she said, he looked like he had a mental illness. Like anybody who met him would know something's not right. And still he was able to buy 3 guns in this state and kill himself with it. Thank you.
Representative Rawlings.
There are concerns about the subjectivity of all of this, and also that the process becomes the punishment. There will be a lot of people dragged into court or whatnot that are they're innocent. And I thought criminal law, you have elements of the law that you have to meet. There's a murder, there's certain elements, there's something to tangible to go to. But in this case, what did these people do? What is the crime? What is the upfront crime? I think it's going to target a lot of people groups, like people in rural areas, good old boy networks. It's going to target veterans. It could target inner city blacks. It could target people within the home, aside from the main target. It could be a problem with who are the petitioners? Who are the accusers? What expertise do they have? Do they have psychology degrees? Can they psychoanalyze? You have so much corruption. And I have a real concern with judges right now that don't all rule constitutionally. And so you have decision makers and judges that may be dealing with ideological concerns. They deal based on their own ideology or their personal policy preferences. So I don't trust the system right now for engaging in these type of issues.
I appreciate that, and all of that's most of that well taken, and I appreciate the comments. But we rely on the system to get it right now. We rely on the judges to exercise their judgment well today. We rely on prosecutors, and we trust them to exercise their discretion well. We rely on the system to capture the people that are guilty and convict them. We trust the system to render not guilty verdicts for those that are innocent. It gets it right more often than not. I can't guarantee you, and no one could, that any part of this or any other bill any of us might file or pass would be followed exactly the way we hoped and intend, because that's just not going to be the case. You're going to have judges somewhere that do this right. You're going to have judges somewhere that abuse it, I'm sure. Thankfully, we have appeals for that, and we have challenges for that. We are talking about a constitutional right, but we're not talking about your personal liberty. It's why a criminal proceeding has quite a bit higher burden and a much stiffer sort of penalty for things that when people break the law. But in this, it's a civil process, and it's a temporary thing. And again, I'm open to any suggestions you've got to increase those protections. And for fraudulent or bogus claims or petitions, right now the version that I have, both of them include just household members or immediate kin, but I think it should be coworkers. It should be somebody else. If Amanda doesn't know that I'm struggling with something, but one of you do, God, I hope you say something to somebody and get me the help that I need. The folks, and y'all tell me if I'm wrong, but I think it was the shooter in Lewiston in Maine, where coworkers said, we knew that there were problems. We knew that he got help or maybe needed help. I think it should be allowed. It can't be wide open. But if there are protections to make sure it's not abused, and by the way, the language, and I think the language even in Morgan and Paul's bill included protections for doing this fraudulently, and we already have criminal offenses for fraud and deceit. But if there are additional protections to protect against someone filing a bogus petition or seeking a bogus petition, please tell me what they should be, and let's throw them in. Mm-hmm. It's not going to be bulletproof, pardon the analogy, but let's make it as safe as we can, because it is a constitutional right we're talking about. Please.
Thank you, Senator. We have several more members who
Sure, and
have signed up to speak, and we've been here about an hour, so
We've
I'm
maxed
going
our
to try
time.
to recognize a few more of them if possible, and I would just ask you to keep your comments or questions very succinct. Representative Burke.
Thank you, Mr. Chairman. Senator Westerfield, Ms. Austin, and all of the panelists, thank you. From the bottom of my heart, thank you for what you've done today in bringing this before the committee. For me, the value of this bill is in the sphere of preventing suicides. After an acute mental health crisis in college, I attempted suicide. By the grace of God, I lived. If I had tried with a firearm, I would not be here today. I would not have my family. I have a lot of friends who didn't have this outcome. I've lost a lot of people to suicide. Presently, I spend a lot of my time working with veterans, and just last week I met a veteran who recently attempted suicide with a firearm, and by the grace of God, he only lost his eye. What he gained was a lease on life, and I have never seen someone more invigorated than that man, who is now working on his mental health and getting back on his feet. I've heard a lot about deprivation of liberty today, and when it comes down to it, we are looking at two different types of deprivation of liberty. Are we going to put people into mental institutions against their will, fully depriving them of the ability to be in their community among their loved ones? Or are we going to deprive them of access to their firearm for a brief time so they can get it back together? To me, that's what love requires. Love requires reducing risks without putting someone into an institution. Senator Westerfield, I'd ask that you'd please consider marrying your proposal. By the way, I like version 2 better, but I would work with you on version 1. I've been working on a bill to trigger, no pun intended, this type of work through the 202A petition. So if a 202A petition is not granted, would you consider allowing that to be a method by which this process could unfold?
I've actually thought about this as sort of a second, like an off exit ramp, short of commitment. So that has been something I've considered. So I certainly would. Thank you.
Thank you very much.
Representative Flannery.
Thank you, Mr. Chairman. 2 questions, please.
Just one.
One. All right.
You can ask me the second one after.
All right. Sounds good. So, in listening to your all's testimony, there seems to be this notion that when someone is suffering from an acute mental health episode, that the judicial branch of government can, in real time, prevent someone from harming themselves or others. And so taking out the constitutional concerns that I agree with, that Representative Maddox discussed, Representative Nemus discussed, I'm trying to figure out how you're supposed to stop someone from hurting themselves or others in real time that's going through an acute mental health episode. I just don't see how that's possible.
It's easier with option 2 than option 1. The ex parte hearing that is so contentious because it's ex parte, that means that the respondent's not there for that initial review, and it's not a hearing, it's the judge looking at the petition and entering a temporary order. But the benefit of that, as I mentioned before, is that that person doesn't know that's about to be ordered, and so they're not acting, and you pray that you stop them in time from doing something horrendous or horrific. If it's under option 1, there's a potential that you don't stop it, to be perfectly blunt. If you inform them, there's not an initial ex parte review by the judge, and you just go to the respondent and give them that option, a hearing in a few hours or a hearing in 2 weeks or in a week. And they choose that option, the latter option, I want to have a hearing in a week. There's absolutely nothing stopping them from lying to you about the guns that they have. Sure, I'll turn over the 5 I want you to have, but I'm going to keep the 6th that's hidden under my mattress. And there's no search, Representative Maddox, or ransacking of a home or anything. I think it's on the honor system. But if they turn that over, but they hide a gun, or if they go and get a gun, and the bill does actually speak to them doing that, which is a violation, they can act. between when you first approach them and when that hearing is. It's why the ex parte hearing is so valuable in the states that have that, or in option 2, as I've talked about, because you intervene before that happens, you hope. Yes, ma'am, please.
Thank you, Representative Herron.
Thank you, Chairman, and thank you all for your testimony on this super complex issue. Some of the things that came up for me is I was 17 years old, a senior in high school, when Heath High School happened, and had not thought about that until you mentioned it. And that's a lot that we are still battling and trying to figure out solutions. Some of the other things that I heard during the testimony was that we need more funding for our mental health centers. Also, I heard a lot about the mass shooting at Old National Bank. For the record, and for those who don't remember or know, also 7 days later in Louisville, there was another mass shooting in Chickasaw Park, which is in my district. And so I say that to say that whether it's a legal gun or an illegal gun, it's not normal for people to shoot and kill. It's going to take a lot for us to address and fix this issue that we're dealing with. I think that it's going to take many tools. I think that this is one potential avenue to get that done. But I do think that we have to take a public health approach. And I think that when we've heard the testimony, that's what we continue to hear: public health, public health, public health. And so I just want my colleagues to know, as we're moving forward and as we come into January, to think about all the different things. Even if we were to pass this bill, this is not going to be enough to address the issues that we're seeing in our communities.
I hate to,
but I
cut
do
you
have
off here,
I have
but
one. Hold on, I have one
want you to
question.
keep it concise.
I have heard that people say that CAR is a red flag law. Can you all just kind of verify and talk about how this is not necessarily a red flag law?
It bears a resemblance to those other states, if people want to call it that. I guess help yourself. But it's meaningfully different in a couple of ways. First of all, the timelines are shorter. The burden of proof is going to be higher, at least in the draft that I have. The burden of proof is higher than what is typically in other states. If it's option 1, there's not another state that has something like that avoids the ex parte hearing altogether. That is a substantial difference from any of the other bills. What else am I missing? Oh, and who can petition? So we talked about that already. There's not just anybody can just go and ask a judge for this. You've got to convince law enforcement officer that this is warranted, and then they've got to convince a judge if it's option 2, or they've got to still have to at some point convince a judge. But it still has that law enforcement step. Now, a 202A proceeding has a mental health expert that's got to sign off on that, and I wouldn't have a problem with that at all. But then you reintroduce the problem that they are now informed that something's coming, and they can act on whatever their targets are. So again, those are the things you're balancing. And so I don't have a problem with adding additional steps, but ours is one of the states, if we were to ever to pass this, it has that law enforcement step, and a lot of states don't.
Thank you,
Did I forget
Senator
anything
Storm.
else?
I'm going to give you 1 minute to ask your question or your comment.
Thank you, Mr. Chairman. Very quickly, you quoted a Heller 2008 Supreme Court case, correct?
Yes, sir. To be accurate, I quoted the syllabus, which is a combination of a couple of parts on page 54 of the Heller opinion, where Scalia still writes what those things that I talked about.
Thank you. So again, I greatly appreciate you. I cherish your friendship and your mental and legal capabilities. Ms. Austin, thank you for presenting today. I'm sorry for what you've experienced. These are very excitable examples of what you've given us today. But today is December 15th, and in 232 years ago, the Second Amendment was ratified, and it says unequivocally, the right of the people to keep and bear arms shall not be infringed. That was 232 years ago today. And you cited the 2008 case, which I appreciate, but there's also a 2022 case brewing.
There is.
And it says that the Supreme Court has held firearms restrictions are now presumptively unlawful unless the government can demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation.
Yes, sir.
The historical tradition is the Second Amendment, correct?
It's part of it. Yes, sir.
Thank you.
Thank you, Senator Neal. If you could please keep it concise and brief.
Nice
It's going to be brief
cross-examination.
because I think my question has been answered in the discourse that's undertaken. I want to thank Senator Westerfield and Ms. Alston for bringing this very important discussion to the table on this legislation. Thank you.
Thank you, sir. Representative Stevenson.
Thank you. I want to thank you for offering to allow people to give solutions and not just do nothing. And that's important. I believe in the whole Constitution. For 27 years, just like people here, I took an oath to the Constitution to defend it against all enemies, foreign and domestic. And I agree with the Second Amendment, all of them. But with every right, there's a responsibility. With every right, there's a responsibility. Even in the military for 27 years, if there was a member that looked like they were going to harm themselves or were undergoing mental health crises, we had a process. And we took away their weapon until they got healthy, and then we gave it back. We've got to be brave enough to not let people just die nilly-willy. There are a lot of dead citizens that are law-abiding citizens because we're not taking action. And we keep saying it's too hard. Well, if it's too hard, then we need to get some people that are willing to do the thinking and save the people that are living their lives right. Look at the Constitution to ensure domestic tranquility. All of that. We are the ones that were appointed. And we can no longer hide under the guise of it's abridging my constitutional rights, because everything we do in this life contends on us living for the greater good and making sure that everyone has the same right to life, liberty, and property.
Thank you, Representative Stevenson. Senator Schickel. Well, we've asked for no applause.
Thank you,
Senator
Mr.
Schickel.
Thank you, Mr. Chairman, for your indulgence. I just have a comment that I don't think has been made, and that is, in my opinion, and I know the folks at the table disagree with me on this, but for at least the last 10 years that I've been in the legislature, we've been basically peddling a soft on crime agenda in the Commonwealth of Kentucky, and we're seeing the tragic results of those policies. And we have so many gun laws on the books right now that are not being enforced, and the perpetrators of them are not being punished. And yet we're discussing laws that potentially abridge or take away people's constitutional rights. At least that's my argument. When we have all these laws on the books already, which we're not enforcing and we're not punishing criminals for. And I just think that needs to be pointed out. Thank you, Mr. Chairman.
Thank you, Senator Schickel, and thank you, Co-Chairman Westerfield, for your presentation and your guests. And
Thank you, Chairman.
the next item on the agenda
Thanks. Good to see you, sir. Thank you.
will be Senator Harper Angel with the crime victims compensation.
Bert, I'm just going to minimize that. I don't know if I need to do anything else on that. All right.
Senator, you're recognized, and you may introduce your guest and proceed. Thank you for being here.
Good morning, Mr. Chairman and members of the committee. I'm Denise Harper Angel, State Senator with the 35th District. With me this morning is the Senate Democrats' Chief of Staff, Becky Barnes. I appreciate the opportunity to be able to discuss BR 135 this morning. This is actually the second year that I've had the opportunity to facilitate a working group of victims, advocates, hospitals, and the Crime Victims Compensation Board. Last year, we came to the committee and passed some statutory cleanup language and made small increases in the statutory caps on damages. This year, we're back to propose further adjustments to the statutory caps and additional duties and simplify board procedures. Since we're short on time, I'll briefly talk about the significant changes. Senate Bill 135, Bill Request 135 requires the Crime Victims Compensation Board to make the application process available online, expand the languages with the application is available, and establish a tracking process for claims where the victims can determine where they are in the process. It clarifies those who are eligible to file claims to include spouses, siblings, personal representatives, and individuals acting as caregivers to victims of crimes. It removes the 5-year statute of limitations for filing a claim with the board. That elimination will keep Kentucky in compliance with the reauthorization of the Federal Violence Against Women Act 2022 and allow victims whose safe kits, sexual assault forensic examinations, were delayed in testing to seek recovery of damages. It expands the types of out-of-pocket expenses to include relocation and temporary housing expenses, tattoo removal for victims of human trafficking, and crime scene cleanups along with replacement of locks and windows. It also increases the statutory caps on emergency awards from $500 to $1,000 and the overall cap for reimbursement from $30,000 to $50,000. Thank you, Mr. Chair, for allowing us today to have the opportunity to speak. I look forward to coming back to the committee in the 24 legislative session. We'll have a final of the draft, and we will also have a fiscal impact statement for the committee.
I have a quick question, if you don't mind. You said tattoo removal. I assume that's for tattoos that some offender, some human trafficker has forced on a victim? Okay.
Yes, Mr. Chairman.
And what are the limits right now? You're raising it. I'm sorry, can you go through those dollar figures one more time?
Yes. We're raising the emergency awards from $500 to $1,000. Last session, we raised the overall cap to $25,000.
Right.
Now we're taking that to $50,000.
How does one apply? And I don't remember if the gentleman from the board mentioned this. How does one apply for emergency funds versus? Is that separate from a full award that you would get?
I believe that's just the first step in the process, and then the formal paperwork comes after that. We're trying to make it online and simpler for applicants and victims to apply.
And has the Victims Comp Board seen this and blessed it?
They have seen it. They've been part of the working group. We've actually met during the last two interims. They will be with me on our next testimony.
Good.
And then you can answer all these really tough questions to them.
I appreciate it. Members, any other questions? All right.
Thank you, Mr.
Y'all didn't want to
Chair.
grill her? Jeez.
I only had a minute.
Mr. Chair, you're a hard act to follow.
Chairman Elliott does have a question.
I
See,
do.
I knew if I waited long
I don't
enough.
have a question. I just want to thank you for your concise, succinct testimony. Thank you.
Touche.
My pleasure.
Thank you, Senator. Thank you, Becky.
Thank you, members of the committee.
All right. I'm going to have Representative Decker head down for her part. And while she's in there, members, happening today, and this is in your folders, I want to draw your attention to a 3-page bio in the back of your folders this morning. And I want to give special recognition to a woman who I think is a hero, other than Whitney Austin, who is a hero, but who is no stranger to this committee, to the work of the people of the Commonwealth, and she is retiring after 35 years with the Kentucky State Police, and that is Director Laura Sudkamp. And she's not here with us today because she is working, and I think there may be a reception for her at State Police today, but there is a fantastic bio with a great picture from when she first began in 1989, and relatively current, I think. Actually, I don't know when that more recent picture was taken. But take a minute and read that. Folks, if you know Laura, reach out to her and tell her that you're thankful for her service. You guys have, for those of you that don't know her, you have no idea how invaluable she's been to the success of our state police crime lab, the system, not just here in Frankfort, but statewide. She is reason why Senator Harper Angel mentioned the SAFE Act. She's part of the reason why those backlogs don't exist anymore, and why they've been able to do so much with, frankly, not enough resources from us. So I wanted to recognize Laura's service to the people of the Commonwealth and the state police. Thank you so much. With that, we've got Representative Decker, and I know we've got a video from Senator Paul, and I see his state director here.
Yes.
Are you coming up testifying too? No, sir. Okay.
He was going to work
Well,
on
that's a
starting
shame.
the video.
Good morning, Senator Westerfield, Representative Elliott.
Oh, wait a minute. It's not time. Yeah.
Representative, you have the floor when you're ready.
Thank you.
I would ask if y'all wouldn't mind make sure those doors are shut. I know there's a lot of folks that were coming and going for car, but it's hard to hear.
You ready?
When you
Okay.
are.
Thank you, co-chairs Westerfield and Elliott, for allowing time on such a busy day to discuss about BR 18, a working draft of a bill I plan to file in the 2024 session to revise Kentucky's violent offender statute. Appearing with me today on video to offer testimony about the topic and the presentation will be the Honorable United States Senator Rand Paul, and Commonwealth Attorney Rob Sanders will also offer testimony as well and present witnesses who will identify themselves at that time.
With us today is also Morgan and Antoinette Miller, who are the sister and mother of Jordan Miller, who was unfortunately a homicide victim in Kenton County in 2022.
I greatly appreciate the work of both the Commonwealth Attorney Sanders, who's assisted in this effort, and the testimony we're going to hear from Senator Paul and the other witnesses. The draft you have of BR 18 amends KRS 439.3401, the statute that sets forth which criminal offenses qualify a convicted felon as a violent offender. I invite members of this committee and stakeholders in the Commonwealth at large to offer thoughts about the bill before it's finalized and filed. All thoughts are welcome. This is, as the bill you heard before, the car bill, this is a work in progress, and we ask for your comments. Under current law, the term violent offender means any person who has been convicted of or pled guilty to the commission of a capital offense, a Class A felony, or other felonies listed in the statute. BR 18 amends this statute to include all felonies that involve the death of a victim or serious physical injury to the victim. In addition, BR 18 amends the violent offender statute to include the attempted commission of the offense listed and deletes offenses that are covered by the revisions that add attempted crimes and include all felonies that result in death or serious injury to a victim. BR 18 adds the following crimes to the current list of violent offenses: burglary in the first degree as described in the statute if a person other than a participant in the crime was present in the building. Burglary in the second degree as defined in statute if a person other than a victim or a participant of the crime was present in a dwelling. Robbery in the first degree as defined in statute, robbery in the second degree. Arson in the first degree as defined by Kentucky statute, arson in the second degree as statutorily defined, and strangulation in the first degree as defined in statute. This bill draft requires all violent offenders, regardless of the classification of their offense, to serve 85% of their sentence before parole, probation, or any other form of early release. And while the bill draft you have been given does not amend Section 4, we are considering whether any amendments should be made and make sense there. At this time, I would like to allow the remainder of my time for Senator Paul's video, and then Commonwealth Attorney Sanders and his witnesses. So,
Good morning, Senator Westerfield, Representative Elliott, and members of the committee. Thank you for the opportunity to testify before you today. On February 14th, 2022, an armed individual attempted to assassinate then-candidate Craig Greenberg, who now serves as the mayor of Louisville, by firing several rounds of ammunition into a room filled with people. The assailant was apprehended and charged with 1 count of attempted murder and 4 counts of wanton endangerment. It was only because of this tragic event that I learned that Kentucky's legal system treats attempted violent crimes differently than successful or completed crimes. The difference is punishment between a violent crime and a nonviolent crime, and it's both staggering and nonsensical, the differences. Under current law, an assailant who successfully shoots and kills another individual with a firearm is required by statute to serve at least 85% of their prison sentence. But if under the exact same circumstances the assailant misses his intended target, current law would allow that assailant to be eligible for parole after serving only 20% of the sentence. We have a duty to protect society from those who act with such reckless abandon or cruelty that an innocent life is put at risk. Only by reviewing real-life examples of how our law treats uncompleted crimes can we fully appreciate the unjust, unfair, or improper outcomes of our legal system. For example, I learned of a drive-by shooting in which the assailant shot at a passenger in another car. The assailant missed the passenger but hit the driver in the arm. The gunman pled guilty to attempted murder of the passenger and assault in the second degree of the injured driver. The offender was sentenced to 15 years in prison, but he was released after only 2 years. That story alone may sound like a miscarriage of justice, but it gets worse. After his release, the offender violated his parole by waving a gun at an individual when driving by the innocent person's home. Fortunately, this particular assailant is back in jail, but our system allowed a clearly dangerous individual to be released from prison back into society after a relative slap on the wrist. In another incident, on February 23, 2022, an innocent woman was out jogging in Kenton County and was suddenly attacked from behind. The attacker attempted to rape the woman, but she resisted. She bravely fought back and fled her attacker, who was later identified and apprehended because investigators found his cell phone at the scene. He pled guilty to sexual abuse and attempted rape. Under current law, this would-be rapist may be eligible for parole, though, after only serving 20% of his sentence because it was attempted rape and not rape itself. Justice demands more than our current laws provide. Our responsibility to the people of Kentucky is to protect them from those who would do them harm. Our current statutes do not adequately punish incomplete, violent crimes. Innocent people are put at risk by quickly releasing violent offenders back into society. Please don't misunderstand me. I do not want to disincentivize prisoners from participating in rehabilitative programs that might earn them good time credits. We must accept the reality that most offenders will eventually be released from prison, and we should do everything possible to ensure that these individuals are rehabilitated so that they are able to live independently without posing a threat to their communities. But the law, as currently written, fails to do just that. It treats conduct that could just as easily have resulted in loss of life or serious bodily harm as though it were a misdemeanor. Kentucky law all but assures that violent individuals will quickly re-enter society without the opportunity to rehabilitate them. Representative Decker is working on legislation to address these issues, and I look forward to reviewing her proposal. I commend Representative Decker for her efforts to find a solution that will ensure the safety of law-abiding Kentuckians. I encourage this body to work with Representative Decker and others to find solutions that treat violent acts as violent crimes and maximizes the safety of innocent Kentuckians. Thank you for the opportunity to address your committee today.
Thank you, Mr. Chairman. My name is Rob Sanders. I'm the Commonwealth's attorney in Kenton County, Kentucky, which is the 16th Judicial Circuit. With me today, as I mentioned, are Morgan and Antoinette Miller. They are the sister and mother, respectively, of Jordan Miller, who was tragically killed in a motor vehicle crash in Kenton County when an individual by the name of Kevin Ferguson was driving drunk and high and ran off the side of I-75 and was so intoxicated that he was probably a good 20, 25 minutes past the city of Florence, which was their intended destination, and so intoxicated that he couldn't tell dispatchers where he was, significantly delaying the 911 response. That individual was indicted for manslaughter. He was convicted of manslaughter. He was sentenced to 5 years in prison in January of this year. However, because manslaughter second degree under Kentucky law is considered I guess technically a violent offense, but it's a 20% parole eligibility violent offense because it is a C felony. He is, with time served, already eligible for parole in February of next year. So I would like to ask the Millers to talk to you briefly about what it's like knowing that Kentucky law classifies the death of your loved one as a nonviolent offense and having to fight the early release of the man that killed their loved one so soon. Ladies.
Thank you, Rob. As Rob mentioned, my name is Morgan Miller. I am the sister of Jordan Miller, and this is my mom, Antoinette Miller. We've traveled almost 2 hours this morning to declare support for the discontinuance of treating manslaughter as a nonviolent crime in any capacity for the purpose of parole. On April 18th, 2021, my sister, Jordan Miller, passed away in a motor vehicle accident where her boyfriend, Kevin Ferguson, was the driver. The investigation found alcohol and drugs in his system as he willingly and intentionally violated the law with her life in his hands. Kevin's case is considered essentially a nonviolent crime, and every year we are forced to dispute his eligibility for parole despite the agony he has caused our family. If you can imagine the person you love most, how would you feel knowing their offense is treated in the same manner as someone forging checks or stealing license plates? You recover from forged checks. You can purchase a new license plate. However, a sibling, mother, and father, a family as a whole, never recovers from death due to intentional negligence. My sister suffered blunt force trauma to the brain, torso, and sternum region. This is after a gruesome travel down a ditch followed by a fatal encounter with a tree. There is nothing more violent than intentional carelessness at the expense of someone's life. Changing this law should be indisputable unless all would prefer the same treatment if presented the same circumstances. It defiles my sister and masks her killer as less vicious, dangerous, and irresponsible than he truly is. It also leads one to believe he has the best intentions when nothing could be further from the truth. We ask for your consideration and thank you for your support.
Thank you, Jordan. As Representative Decker mentioned, the main changes that this bill makes is to treat any offense that involves the death or serious physical injury to a victim as a violent offense, and also to include attempted commission of violent offenses as a violent offense. It also adds a short list of offenses that I think common sense would tell us is a violent offense. Surely if you ask any of your constituents, if someone burns their house down or strangles them, would they consider that a violent offense? And I think if you ask your constituents, the overwhelming response would be yes. I'm happy to answer any questions you might have about this. And as Representative Decker said, this has been an ongoing discussion. I'm sorry, did you have one too? Yes, ma'am, go ahead.
Jordan is my daughter. That won't change. The weeks and months that followed her death were an absolute nightmare, a parent's worst dream. Grieving the loss of my baby, my 23-year-old baby. Communicating with law enforcement, watching my family be torn apart, all the while knowing that my daughter's killer was getting on with the business of his life. No phone calls to us, no real remorse, No, can I help? What can I do? Nothing. Finally, after over a year, he was arrested. The justice system was working. And it was on our side, and we could face the legal part of this devastation, get justice, and put that part of this tragedy behind us. Or so we thought. Meetings with the wonderful prosecutor, Rob Sanders, determined a charge of manslaughter would be the most appropriate path forward. The charge carried a sentence of 5 to 10 years. My daughter was gone. As much as the charge and the sentence hurt me to my core, I had no choice. I needed closure, and I needed to grieve my baby. Kevin was offered and took a plea deal of 5 years. I was injured beyond repair. Insult was added to that injury when I learned Kevin wouldn't do the entire 5 years. That despite us appearing at every parole hearing, he would not serve that entire time. And we would need to relive the nightmare every time he came up for parole. No matter what we did. On April 18th, 2021, my family and I were sentenced to a life sentence. No discovery, no due process, no trial, no nothing. Life. There is no parole board for grief or loss. No one to say, oh, you did a good job. You went through all the 5 stages of grief and now you're done. You get your life back. I don't get my life back. But you're telling me that Kevin won't even serve 5 years and that a mother who goes through this or another person will have to deal with this? That's not justice. That's not fair. I don't look for the law to make me whole or anyone in this situation whole. It's impossible. I'll never be whole again. But what I do expect is justice. He should serve the minimum at the very least, and that's not enough. I thank you for your time and consideration.
Thank you, Ms. Miller. Ladies and gentlemen, with all due respect to all the other sponsors of the various bills that have been filed for the next session, I really think this bill will do more for public safety than any other bill I've seen going forward, as well as any other bill I've seen in years. I think it will do it will accomplish 2 main goals. Number one, it will keep violent offenders off the street for longer amounts of time, allowing them, as Senator Paul noted, an opportunity to be rehabilitated after serving a meaningful sentence. And it will also spare crime victims like the Millers and unfortunately the many thousands of others like them in Kentucky that have suffered the loss of a loved one or suffered a serious physical injury. I think that those crime victims deserve the justice that 85% parole eligibility brings in situations of death or serious physical injury. Thank you.
Thank you, Rob. Thank you, Mrs. Miller. Thank you, Ms. Miller. I appreciate that. Representative Decker, thank you. Representative, go ahead.
Thank you, Mr. Sanders. I just want to point out how much, how it seems like sometimes we're looking for things to fix in the criminal justice system, how to address crime in certain ways. Excuse me. I just want to point out how important and how much this would do. The violent offender statute and the list of the crimes on here needs cleaned up. Strangulation is not on there. When a man strangles his wife, that's not considered violent. I think probably because it's a new offense and maybe it was just overlooked. But for example, we're about to talk about carjacking. That's something we should keep in mind when we look at these crimes. One example is third-degree assault, causing someone a physical injury by assault, is a non-violent offense. However, third-degree assault of a police officer, Mr. Sanders, that's violent, right?
But not under it's 20% parole eligibility under Kentucky law.
But there's a harsher parole based on who the victim is.
Not unless you kill the victim, no.
Okay,
Under
okay.
current Kentucky law, any C or D felonies are 20% parole eligibility regardless of what the crime is. So assault on a police officer or assault third degree is a Class D felony. All Class D felonies, well, I shouldn't say all, some are 15%, but none are higher than 20%.
But we both agree they should both be considered violent offenses.
Yes, sir. I think it's absolutely tragic that we tell some crime victims when they've suffered death or serious physical injury like the Millers have, that Kentucky law classifies it as nonviolent. It's insulting to the senses as well as just to the sense of justice.
Okay, and one other example I want to give is in Whitley County, we did get a 15-year sentence on manslaughter for someone who distributed drugs, caused the death of the person, and that's something we're specifically looking at maybe considering it a harsher penalty. But the law is there to consider it manslaughter. So this 15-year sentence should be enough. However, it's only 3 years. After 3 years, they're eligible. When a jury comes forward with a 15-year sentence, we deserve to our Commonwealth to at least see 85%. That's a great number. The 3 years for a homicide, it's just not acceptable. So I appreciate bringing this bill forward. I think it will do a lot more than what people realize. Thank you.
Representative Flannery, last question on this one.
Thank you, Mr. Chairman. Mr. Sanders, Senator Storm and I were, discussing this. It's our understanding that all violent offenses are 85%. Is that correct?
No. The only violent offenses that are Class A or capital offenses, Class A or Class B felonies. There are violent offenses that are C and D felonies. However, they get 20% parole eligibility. So calling them violent doesn't mean anything. You can call them violent all day long, but if it doesn't carry 85% parole eligibility, what difference does it make? So this bill would fix that.
Okay, so I'm trying to, understand what the fix is. So manslaughter 1 is categorized as a violent offense, but it's not 85%.
Manslaughter 1 is a violent offense because it's a Class B felony and it involves the death of a victim. So that is a violent offense. Manslaughter second degree, however, even though it involves a death of a victim, is not an 85% parole eligibility because it's a Class C felony. It's still technically a violent offense, but it doesn't carry the 85% like the Class B felonies do.
So the fix is to make everything that is categorized as a violent offense 85% because
yes,
they
sir.
are currently not all at 85%.
Correct. This bill would not create any new felonies. It would not extend any punishments or create larger punishments for any felonies. All it would do is ask for truth in sentencing, and that the offenders serve 85% of whatever their sentence is, whether it's 1 year or whether it's 70 years. Well, again, that one's a misnomer. Bad example because 70 is capped at 20 years parole eligibility. But whether it's a 20-year sentence or a 1-year sentence, it would be 85% of the sentence and take out the classification of the felony offense.
All right. Thanks, sir.
Thank you all. Thank you, Representative Decker. Mrs. Miller, Ms. Miller, thank you both.
Thank you.
That brings us to the Safer Kentucky Act.
Everything that's violent should be 85.
I want to welcome Representative Jared Ballman up, one of the distinguished members of the mighty large Jefferson County contingent.
I don't necessarily disagree with that.
Representative, you have the floor when you all are ready to go. And I anticipated we'd go over on time, and we are going to go over on time to give you all the time we promised you'd have, but you're it. So proceed.
It's got an element of unlawful touching.
All right, thank you, Chairman Elliott. Thank you, Chairman Westerfield, for providing me and my team the opportunity to present the Safer Kentucky Act to your committee today. We are delighted to be here and also thank the ladies and gentlemen of the committee, and we look forward to your feedback on our proposal.
I'd like to start by connecting our vision to the proposal, and that is a vision of unstoppable prosperity for the 4.5 million Kentuckians we are blessed to serve, and to make Kentucky the greatest state in our nation. And so in order to achieve that, if you think of that unstoppable prosperity for the 4.5 million Kentuckians we serve as the top of our house, we have really 4 pillars that support that: a strong economy, the Kentucky family, education, and quality of life. And there are principles, concepts, and practices within each one of those pillars, and we can talk about those a little bit later. But foundational to all of those, the foundation for our civilized society here in Kentucky is public safety, security, and protection. And our foundation is broken. We face an epidemic of crime in our hometown, and we continue to see record rates of homicides in urban and rural areas across the state. In Louisville alone, victims have suffered 708 carjackings, violent carjackings, over the last 4 years. That is an average of 1 every other day, just nearly. Our overdose death rate in the state of Kentucky is 57% higher than the national average, and retail crime alone is costing businesses over $1 billion per year in our Commonwealth. And the simple truth is that the criminal element has become an all too normal part of our world today. Our constituents are fed up. Kentuckians are fed up. Across generations, we are failing to provide the necessary foundation for Kentuckians to achieve prosperity. From those sunsetting in our state that want to retire gracefully and peacefully in their community, to my generation that is raising a family and working in our state, and to our youngest generation, our most important generation, our kids and grandkids who are growing up in a world today in an environment that normalizes crime and criminal behavior as just a regular part of our daily lives, as we all hope and we all pray that one of our family members or one of our loved ones isn't the next victim or statistic. And so what is our role in providing the strong foundation we so desperately need? What can we do? Of course, we can and will continue to invest in law enforcement, and we can and will continue to provide checks and balances for the judicial branch. But as the legislative body in our state, it is our duty, it is our job to provide the strongest and most effective policy possible to hold criminals accountable for their actions. This will be critical in providing that foundation of public safety, security, and protection. And the truth of the matter is that the majority of Kentuckians do not support soft on crime policies that treat law enforcement harshly and let criminals off with leniency. And so as we go through this proposal, you will see how every component of the Safer Kentucky Act will provide the critical foundational support for a thriving economy, the Kentucky family, excellence in education, and the highest quality of life in America. I'm going to cover these provisions on the PowerPoint here at a high level. I know you guys have the bill in front of you in your meeting materials, and so we'll take the questions at the end. The first provision of 3 strikes law, which will require life in prison for any experienced criminal that commits 3 violent felonies in our state. Next is removing early release for anyone that uses a crime that is possessed illegally in the commission of that crime. I'm sorry?
A gun illegally.
Oh, I'm sorry. Yeah, that possesses a gun illegally and uses that in a crime. They will not be eligible for early release of any kind under this provision. Requiring parents to attend juvenile court hearings. This will impose penalties on parents that do not stand next to their child as they are before a judge in court. Enhancing the penalty for fentanyl death by delivery. Look, we know that this poison is killing our people every day in Kentucky, right? These are some of those faces right here. And so we want someone that knowingly sells fentanyl, this poison, for profit motive, and kills someone, that they are charged with murder under the Safer Kentucky Act. Next is creating a Kentucky state carjacking statute. We do not have this today, and it will establish this statute with the Class B felony classification and also add it to the violent offender list. This will the vandalism provision will reduce the felony threshold to $500 and also allow for that to be reduced to a Class B misdemeanor if the offending party makes a qualified restitution prior to the trial. Smuggling contraband into a detention facility is a significant problem in our corrections facilities. And so if it is fentanyl, carfentanil, or other fentanyl derivatives, that is going to be a Class B felony under the Safer Kentucky Act. Modifying the rules for weapons used in murder. This will allow weapons that are used in murders to be destroyed if the bidder so chooses to designate that gun for destruction. This is for murder weapons only. The street camping provisions are in place to protect the rights of property owners, public spaces, and business owners across the Commonwealth. So this will ban street camping on public streets, in front of businesses, on private property, and it allows local governments the control to establish areas for this camping to occur. Improving protocol for involuntary confinement. This will remove the loophole that requires a demonstrated history of criminal behavior before involuntary confinement can occur. Supporting successful reentry, we are going to make it mandatory that everyone leaving incarceration receives a state-issued identification from the Transportation Cabinet. Regulating bail funding organizations. This one hits pretty close to home, as this beautiful young woman was killed by somebody bailed out by the Bail Project, was murdered by a gentleman high on drugs, speeding in a stolen vehicle down the wrong side of Dixie Highway. And so we want to limit bail funding organizations to $5,000 and not allow them to post bail for anyone in for a violent offense. A new statute for the murder of a first responder will establish the death penalty or life in prison for anyone that murders a first responder in lawful performance of their duties. I do not believe it is actually in the bill in front of you, but the intent is to require that they also pay compensation to the victim's family. Reforming the parole board allows for a 2/3 vote of the full board to approve parole. Strengthening shopkeepers' privilege will allow business owners and employees to use reasonable force to detain criminals to prevent loss of goods for sale. Increasing the penalties for attempted murder. We just heard a little bit about this, but this will add attempted murder to the violent offender list and ensure that they serve 85% of their sentence. This will broaden the terroristic threatening statute to include the workplace and threats of violence in the workplace. This will require that a school report any threats of violence or any deadly weapons that come into schools to law enforcement. That currently does not happen today. We want to make that state law. Hardening sentences for adults using juveniles as criminal accomplices. This one is very important because in the city that I live in, juveniles are orchestrating organized crime, adults are orchestrating crime using juveniles, and we want to make sure that these folks that are doing this are held to the highest account possible. I would certainly appreciate anyone that can help strengthen this provision, because what we have today is that they will be charged one level above the normal charge for that offense. Cracking down on drive-by shooters will create wanton endangerment with the discharge of a firearm as a Class C felony, and also add that to the violent offender list. We have a reckless disregard for human life in a lot of areas of our country today and of our state. This young man before you here was murdered as he waited for the bus to go to school. And so we have to come down hard on people using guns, firing them just freely into streets, into homes, into cars, and that's what this provision will do. Updating the witness intimidation statute to include harassing communications that are sent electronically. Reducing recidivism by compelling those granted parole to participate in group violence intervention. Improving the protections for victims of domestic violence by increasing the penalties for those who repeatedly violate protective orders. Supporting successful reentry. This will require regular evaluations of our reentry programs to ensure that we know which ones are working well, which ones are not working, so we can apply funds appropriately for the betterment of the Commonwealth. And lastly, I believe, is Jake's Law, cracking down on those fleeing the police. It increases the penalty to a Class C felony and requires 50% served. This one is named for Jake Luxemberger, who again was tragically murdered by someone in a vehicle that fled police, who was bailed out by the same bail funding organization that bailed out Madeline Trout's murderer. And so this bill is named after him. So, ladies and gentlemen, thank you. I'll end right where we started, with the vision for safety, security, and protection as the foundation for unstoppable prosperity in our great Commonwealth. With your help, we will use the remainder of this year to sharpen this act and make it the best version possible for the 4.5 million people that we are blessed to serve. I know I went through that rather quickly at a very high level. I'm sure that you've read the bill and have questions, so I'll be happy to take those.
Thank you, Representative. I appreciate the work that's gone into it. You and I had a lengthy conversation yesterday about a number of provisions in last week's version of the bill that I was able to see on Friday. I have not had a chance to read through today's version yet, though we sent that out yesterday, so members do have that. And so I'll follow back up with you at another time. We do have a couple of questions from other folks. Representative Blanton.
Thank you, Mr. Chairman. Thank you all for bringing this very comprehensive piece of legislation. You cover a lot of things, from not just crime, but reentry as well, right? But I got a couple questions. One, you mentioned in one portion about possession of gun and the commission of a crime, but you say a gun that is not legal to possess. It does an enhancement.
That's right.
I would like to see that a gun in possession, period, brings an enhancement. If you have a gun in your possession and you're committing a crime, in federal law, if you have a gun in your possession and you commit a crime, it's an automatic additional 5 years, unless the statute's changed. It's an automatic 5 years added to your sentence. So I'd like to strike the words that it's illegally possessed. But if you simply have a gun in your possession during the commission of a crime, there's an enhancement penalty for that. If we're going to get tough on crime, let's get tough on crime.
Yes, sir. I really appreciate that feedback and your comments. This is a very well-balanced proposal, and we will take that in consideration. And as we go through the remainder of the year, I'd love to work with you on that.
Okay, thank you.
Thank you.
Now, next question. You brought up Miss Trout. And what was the date on that of her?
2021, I believe it was.
2021.
The exact date.
If I could answer that question, I want to first of all, Representative Blanton, thank you, because this is a portion of the bill that was your bill in the House that we passed, and it was after Miss Trout's death. But the House passed that bill and the Senate didn't. And since you passed your bill through the House and the Senate didn't pass it, there was a young man named Jake Luxemberger. We've seen a picture of him. He died. He was bailed out after we passed it. I wish the Senate had. And Jake Luxemberger could very well be alive today. And he was bailed out by the same organization, and he wouldn't have been able to be bailed out had your bill passed, Representative Blanton. So thank you for the work that you've done on that. That is now incorporated into this bill. And had that bill passed, Jake Luxemberger would probably be in school this morning.
Thank you, Representative Nemus. And that was the very point I was going to get to with this. I was going to Jake next after Miss Trout. And really would like to have his picture put back up there and say, you know what? Why didn't we pass this? This young man would have still been alive today if the bill that we passed in the House had made it through that year, Jake would have still been with us. So maybe you want to talk to Jake's family and explain why we couldn't pass that.
Mr. and Mrs. Luxembourg will be here during the session.
Very good. Thank you.
We've got a number of folks that are ready to testify and support. They deeply appreciate the effort of this incredible team. Sadly, we don't have time for that today, but we will hear from them during session.
Thank you all.
Thank you,
Mr.
sir, for the
Chairman.
work you did on that bill.
Thank you all.
We've got a handful of more folks that have questions. I would just ask that we keep it concise because we are now on borrowed time of everybody's schedule. I know it's important, but I also want to be sensitive to people's time, and I don't want us to go excessively over here. Senator Wheeler.
Thank you, Mr. Chairman. I want to thank these members for bringing what I consider to be a very, very good bill, and I also want to thank Senator Blanton. I was for his bill the last time.
Don't demote him, Representative Blanton.
I'm sorry, Representative Blanton. I think that was a very good bill on the bail organizations the last time. It's extremely unfortunate it didn't pass. Do you all have actual data? I believe that, does the data indicate that in places where you take soft on crime approaches, that crime increases when you take common sense approaches like these, crime actually goes down?
Yes, sir. We do have that data, and we have the data to support just the negative impact that crime has on those four pillars that I discussed earlier, on our economy, on the Kentucky family, on education, and the performance, the poor performance that can be directly related to crime in your community, and then generally the quality of life for Kentucky. And I'd be happy to share that with you.
So everything you're trying to do here is actually based on empirical, proven evidence.
That's
Isn't
correct,
that
sir.
right? Thank you very much. I think that's a very important point.
Thank you.
I'm eager to see it
Yes, sir.
because I haven't.
Well, I do want to note that I got two situations I was looking at this morning. One of the provisions, and the whole thrust of this is to address violent crime very seriously. I was looking this morning, I got a guy named Ethan Bishop that just got sentenced to raping a 12-year-old, 4 instances of previous violent offenses. He would have been under this bill, he would have been at the house being prison. LWOP. That 12-year-old wouldn't have been raped. Another one I was looking at in Fayette County, Mr. Mulazine, convicted of murder. He had 4 previous violent offenses all over the state of Kentucky. That person would have been living because Mr. Mulazine would have been at the house for the rest of his life. So we talk about prevention. Best way to prevent somebody from killing somebody is if they have a history of violence, put them behind bars. That's what this bill does. It's one of the things this bill does.
Thank you. Representative Kulkarni.
Thank you, Mr. Chair. Thank you all for presenting. I know that a lot of thought has gone into this bill, and believe it or not, I'm not in opposition to every single provision. I appreciate you adding workplace. I appreciate you increasing the repeat domestic violent offender penalties and requiring ID for folks that are being released. I know that there's not a lot of time, Mr. Chair, so with your indulgence, I'll just make a couple of comments. We got this bill pretty late. I do appreciate you getting it to us before committee, but we have not, probably a lot of us, had a chance to parse through a lot of the different provisions. It's a 68-page bill. I know you went through a pretty, cursory summary of each of the provisions because of its length. There's a couple of provisions that jumped out at me almost immediately, and one of them is the 3 strikes law that we're proposing here. And I have a few just comments about that involving judicial discretion in terms of sentencing. We're just removing that entirely. Second, we have sentencing credits that we are supposed to implement in terms of like good behavior, in terms of education credits, valor credits. This would remove any of those incentives for individuals to get credit because they're going to be there for life without parole. And so I have concerns about that because I don't know how constitutional it is that we're taking away all of that discretion from our judiciary. And finally, I've had the privilege of attending a national summit, excuse me, I'm still getting over a cough, about criminal justice reform initiatives. And there was a lot of data presented at that summit as well. The trends being nationwide, moving away from greater incarceration, moving away from greater penalties, and increasing categories of penalties for which we incarcerate individuals without having any further nuance. I mean, 3 strikes laws have been around since the 80s and probably longer than that, and haven't worked. The data does not show that those laws work. So I am also interested in seeing what evidence any of these provisions are based on. Just hearing some of the data recently in the last couple of weeks, including over the past 30 years, that property crimes have decreased by 71%, violent crimes have decreased by 70% nationwide. And the second thing, if you don't mind, I think Chairman has left, but anyway, I'll just keep going. The other provision that really concerned me is how we're authorizing and almost encouraging individuals to use force against other folks that are homeless and that are shoplifters. We're proposing these provisions in a state that has no laws in terms of background checks, permits, training, storage for firearms. And you're saying that a person that works for a store or a retail establishment, if they think someone is doing something, again, these are not post-conviction, no one's gone through trial. You're in a store, you work for the store, you think someone's shoplifting, you are authorizing them to take physical force measures if they so deem necessary. Again, there's no guardrails that I saw presented or that I read in this bill in terms of firearms, and you grant them immunity. You grant them civil and criminal immunity for any measures that they decide in that moment based on their subjective feeling on what a person is or isn't doing. All of these provisions are going to disproportionately impact Black and brown communities. But beyond that, what really concerns me about this almost encouragement of vigilante behavior is that you're going to also have individuals with mental illness, you're going to have individuals with communication disorders, individuals that don't speak English as a first language and aren't able to explain very quickly to somebody who thinks they're doing something wrong that they're not. So I'm very, very concerned about the people that are going to be kind of falling through the cracks and swept up in this effort, and I understand the effort is to get our public, our community safer, but I am not sure that we're going to be doing that by criminalizing individuals, more individuals, and making sure that we somehow are turning civilians against each other on the basis of their subjective reasoning. So those are a few of my comments. I'm hopeful that you are willing to sit down potentially with me, with anybody else that might have concerns, including members of our judiciary, members of law enforcement, our corrections department. I'm also concerned about the cost of all of this. I don't know. We're talking about incarcerating a lot more people going through our criminal justice system. There are a lot of questions here. And I hope that you're open to having conversations about some of the concerns that I've raised here today.
Yes, thank you, Representative Kulkarni. I certainly am open to meeting with you or anyone that wants to come to the table regarding the Safer Kentucky Act. As we have developed this policy over the last 6 months, we have been wide open to any stakeholder, any constituent, anyone at all that wants to talk about this policy, weigh in on it, and help us adapt and adjust to make it as effective as possible for the state of Kentucky. So you're more than welcome, and we will compare data. We will have those conversations. And when it comes to the cost of doing nothing is untold. The cost of doing nothing is Jake Luxemburger, is Madeline Trout. And crime is costing America, by conservative estimates, $5 trillion a year. Kentucky's piece of that pie, by conservative estimates, is at least $35 billion a year, more than our biennium budget. So we must take action now, and we will. Thank you.
Okay. With all due respect to Representative Kulkarni, I'm going to ask the next three not to talk that long or to give comments that long. Please, just because we're over. Representative Burke, then Herron, and then Senator Storm, and that's it.
Thank you, Mr. Chair, and thank you all for this presentation. I'm impressed by your brevity. A 68-page document deserves more time than we're giving it today. The things I want to point out for everyone here and the people across the Commonwealth. Kentucky has the second lowest crime in our region, the 14th lowest in the country. We had a 33% drop in homicides in the last 2 years, but we have the 7th highest incarceration in the world. So if putting people in prison was going to solve our problem, it would have already. Unfortunately, it's proven out by the justice statistics that's not the case. I really want us to look, though, at how we're stratifying the poor and the rich, because what this bill does is sets up a system where if you're poor, you're going to have a worse time. And that's already what's happening. We need to do better. Being able to pay off your vandalism is a privilege. Not everyone's family can come up with $500 to make up for a juvenile's mistake. Putting a parent or guardian on punishment for not showing up to a court status offense hearing. Think about who doesn't show up. Those are the people who are working minimum wage jobs who are going to get fired. So if you take them out of work for a week, they're going to be looking for another job. And you know what's going to happen? They're not going to be able to monitor their kids. So that's not a solution. And then finally, I really am bristling at the suggestion that this was wide open to stakeholders because you've proposed eliminating the housing first model of treating homelessness. That is the basis of my career. I've been working with people experiencing homelessness for more than a decade. And what this bill says is that you can't provide permanent housing unless there's a treatment program as a condition. And there's more than decades of research across the country and across the world that shows that housing first gets dangerous, drug-addicted people off the street, and then you can start working on those things. But it's not a condition of starting your treatment and then getting housed. It's getting housed and then starting your treatment. And those things need to go in that order because that's what safety is. That's how you help people start fresh. And I believe you that you want better outcomes for Kentucky, but we need to work on this. And so I'm grateful that you're open to that.
Yeah, thank you. I appreciate those comments. And just to follow up, we absolutely did meet with the Homeless Coalition, and we adapted and adjusted the policy based on what we learned from that meeting. And we'll be bringing, I believe, Representative Whitten, other proposals forward outside of the Safer Kentucky Act to help with the homelessness crisis that we face in Louisville and across the state. And I believe Representative Bratcher wants to make some comments as well.
I just want to quickly say that in 2019, I was with you guys on this. We have incarcerated too many people. And then you say the homicides are down. And they might be down. But you know that only 52% of homicides are the murderers are caught and prosecuted. So that puts a whole nother light on it, that half of the people that are committing homicides out there are not even caught. So to say that there's too many people incarcerated takes out of the equation that there's a lot of them out there that don't even come into the statistics. Thank you.
Thank you. Representative Herron.
Thank you, Chairman. Thank you all for your presentation. I think that my colleagues have said a lot. I do have a couple of comments. One, this interim, I spent some time on the jail and prison work group, and some of the issues that we talked about in that work group. I think that this bill would exasperate those issues. However, I'll juxtapose. What I'm going to say is that I am not someone who is typically for increasing penalties or creating new criminal codes. But if we are going to pass something like this and we want to do something for firearms, I have two suggestions. One, we need to hold accountable those individuals who are legal gun owners and are not locking their guns up and their kids have access to them and are taking those guns and shooting them in the school system or accidentally shooting them. I believe Senator Neal and some other folks have in the past filed a bill. I believe it was called Baby Dre's Act. I will allow him to speak for that, but I would love to talk about how do we hold those legal gun owners accountable who do not keep their guns safe. That's the first thing. That's the first. Well, I guess it's the second one as well. For those guns that are being stolen out of cars, we need to also, if we're really serious about getting to this issue, if we're really serious about what we've heard all day in this judiciary, we also have to make sure that we're doing it across the board And so, again, with the firearms, if legal gun owners have their guns not secured, whether it's in the house or in the car, those individuals also need to be held accountable. Thank you.
Senator Storm, this is the last question.
Thank you, Mr. Chairman. It's just a point of clarification. So my good esteemed colleague has already left, Representative Blanton, but the statute he's talking about is 18 U.S.C. 924C. It only requires the mandatory minimum 5 years increased in the event you possess a firearm in furtherance of the criminal activity. So I just wanted to point that out. Thank you.
Mr. Chairman, if I could just real quick before Representative Ballman closes, I want to just make 3 clarifications. This is not your traditional 3-strike law. Representative Cole Carney erroneously brought that up. Most of your traditional 3-strike laws have to do with any 3 felonies. It could be stealing my phone. This is 3 violent felonies. Only violent felons count. And if you commit 3 violent felonies, this bill puts you to the house for the rest of your life, not to prison. That's what I mean by the house. So that's what this does. This is only violent. This is not your traditional 3-strike. Number 2. The mantra about you getting this too late, we've been talking about it for months, and session hasn't started and won't for weeks. So we've got plenty of time. So there's no you got this too late. We've had a lot of conversations. We're going to have a lot more conversations about it. But I want to say this finally. Just a few days ago, my police chief in Louisville, by the way, shootings and murders are not down. They're not down in Louisville. We had 121 kids get shot in 2021. 24 of them shot and killed. These are kids that should be in school. Thank God they didn't get shot in school. So don't bring this that the violence is down. Violent crime is not down in Louisville, and it's driven by mostly youthful people. But here's the point I want to make. Our police chief said the other day, when we get somebody that we catch, we take them federal. That's offensive to me as a state legislator. They ought not take the serious criminals federal. They should be able to take them to state courts, and the state laws should be serious enough. They shouldn't have to do the petty ones in the state and hope the feds do what's right. We got to do what's right. I want them to take them state, not federal, when they're hurting our people.
Representative, you have any closing remarks, or do you need to recognize any of the rest of the folks behind you?
Yes, sir. Thank you for that. I neglected to do that, so thank you. On the work group with this, we have Jason Nemus and Kevin Bradshaw, obviously, but behind us is Representative John Hodgson, Representative Susan Witten, Representative Ken Fleming, and Representative Emily Callaway as lead co-sponsors on this proposal.
Thank you all. Do we have any housekeeping or anything? No next meeting. See you in a couple of weeks, I guess. But I want to wish everyone a Merry Christmas, Happy Hanukkah, and Happy Holidays. Thank you all so much. We are adjourned.